So you've just landed the job of your dreams, which is with a six-figure salary, health insurance, and 401k, you signed on the dotted line immediately. There's only one problem. The job is in California, and you've got to worry about your lease in New York City. You've got to now make that dreaded call to the landlord asking, can I break my lease? Our guest today is Jamie Heiberger Harrison from JH Heiberger PLLC. Jamie is a 30-year veteran in transactional and residential real estate litigation here in New York City. She has 3 kids, 2 21-year-old twins and a 14-year-old, as well as 3 rescue dogs. She has offices both in New York City as well as Long Island, and even has her own continuing education school to empower agents to learn more about their craft. Jamie, welcome to Managing Manhattan.
Thanks for having me. Great to see you, Dylan.
It's great to see you, and I'm so excited you're here today. I literally have 1.5 million questions of this whole concept of duty to mitigate damages, which we're going to discuss. I know the bigger picture rules, but there's all these intricacies, so I'm happy that we get to go through those today with you, an expert in this field.
Thanks. Great topic. Looking forward to the questions.
Great. So, Jamie, first of all, can you tell everybody what exactly is duty to mitigate?
So duty to mitigate in a basic sense just means that a person has a requirement to do something, take some form of an action to reduce the costs, the risk, the damages that are going to result by what has transpired. So in this case, it's breaking the lease. So the lease is broken. Now the onus is on the owner, who now has to mitigate the damages, meaning the owner's not going to be collecting rent. So the owner has to take active steps to minimize how much rent he doesn't collect. And that's basically just what it means.
Perfect. So the landlord has a responsibility to go out and find a new tenant to replace the tenant that's breaking their lease, correct?
Correct.
Or has abandoned the apartment, in a sense.
Yes, correct.
And now, my first question here is, can the tenant just move out for any reason? So I lost my job, or I'm being relocated to California to take a new job, or my girlfriend dumped me and neither of us can afford the rent on our own. Can it be any reason that the tenant just decides to leave and therefore the landlord's responsible for mitigating those damages?
That's correct. As of June of 2019, when the HSTPA was enacted, from that point forward, any tenant, rent stabilized, free market, co-op, condo, renter, doesn't matter, has the right to cancel their lease.
Perfect. For any reason they want?
For any reason that they want.
Wow, okay. That definitely put landlords to a big disadvantage, but let's talk about it in practice. So when does duty to mitigate start? Like what's the official kickoff of when landlord has to step in and try to mitigate those losses?
The minute that a tenant turns over the keys, they've returned possession to you. At that moment, it is the owner's obligation to mitigate their damages. And if they don't do that, then they're not going to be entitled to collect the lost rent or damages that occurred as a result of the tenant breaking their lease early.
Perfect. And what are so what are the steps that a landlord would have to take? So the tenant just showed up on my office, threw the keys on my desk, said, I'm out. What do I as a landlord have to do now?
You would have to take your active steps to re-rent the apartment. So what is that going to mean? Well, in order to take a reasonable effort to mitigate those damages, that would mean relisting the apartment. Now, if the place was trashed, then the owner would take pictures and have to get it back into a proper condition to be able to rent it. So the cost to do that would be their damages. The biggest problem that landlords cause themselves, I should say, is that too often they don't want to charge the rent that was just charged because it's lower than it might be right now. And so if you don't do that, if you don't charge the same or a lower rent, then the law is going to tell you that you didn't take good faith effort, make a reasonable good faith effort in order to mitigate, because it says the same or lower. And if the rent, let's just say, was $3,800, but the market right now is $4,500, so the landlord says, well, I'm going to list it at $4,500, but now for whatever the bizarre reason, no one rents it. Brings it down, $4,200. No one rents it. Well, guess what? He didn't make a good faith effort to mitigate the damages because he started out of the gate at a higher rent.
So I read an article, I think it was written by Sam Himmelstein, who's a very big tenant protection attorney. And he wrote an article that said that under duty to mitigate, if I try to increase the rent by even $1, so if I'm getting $5,000 today and I put it on the market for $5,001, that I've breached duty to mitigate just by asking for that additional rent, or we don't know yet?
I don't know that would be, that might be a little bit extreme. When we go back to when the law came into effect, it comes into effect and months later it's COVID. It's also challenged once it's out there. So now it's challenged, so it's stayed. Then it's COVID, and then courts are shut down, and then everything's really behind. So we're really, shockingly, I should say enough, because it's 2025, there's not a heck of a lot of cases out there that have addressed it.
Right.
I think, and it's not that there's not lawsuits for it. I have lawsuits that I've brought and defended, and some of them, for the most part, to date, they've been settled or dismissed.
Right.
One of the two. I haven't had one where there's a decision and they had to determine whether or not. I think $1 would be, I don't know, with all due respect, Sam, I would say that might be pushing it.
Right.
It's sort of like when somebody is selling a property and they don't want to have to pay the mansion tax, so they go 9999999.
Right, to kind of game the system.
Yeah, well, guess what? The IRS may turn around and say, this is obviously you did this just to avoid paying the tax.
Right, so we're going to hold you accountable.
Exactly, it could happen. I don't know any time that it's happened, but it could.
Right, absolutely. So you mentioned in this concept that if the tenant trashes the apartment, what can we hold the tenant accountable for, the outgoing tenant? So, trashing the apartment, is that, they've actually trashed it like, professional tenant style where they trash it, or I've got to pay for a turnover? Like, can we hold the outgoing tenant accountable for turnover work?
Well, look, you can hold them accountable for turnover work that you couldn't hold them accountable for if they stayed through the expiration, to the extent that you're going, for example, you rent the apartment to them, they move all their furniture in, it's kind of junky, they decide that they're just going to leave it there.
Right.
Obvious cost you're entitled to.
Okay, so that's an obvious one.
Yeah, that's an easy one.
But like they hung some pictures on the wall. Now there's holes and there's scuffing. Can I charge them? Because I literally just paid $5,000 to paint the apartment. You were there for 2 months or even 8 months, and now I've got to, the new tenant's going to expect the apartment to be delivered in great condition. Can I charge the outgoing tenant back because I've got to repaint it? I've got to clean it. You jam the drawer, whatever it may be. We can charge back that cost to the outgoing tenant.
The first thing I always say to clients is the tenant moves out. Don't forget that no matter what, you still have your 14-day rule with respect to returning the security deposit. And if you don't do it the right way, they're going to get that credit. So you want to be careful there.
Wait, hold on, stop. So if they move out early, I still have to pay back their security deposit?
Yes. Oh. But here's the thing. The problem is you only have 14 days.
Right.
You might rent it within 14 days.
Right.
So you can't, so it sort of depends where the move-out date falls in the context of the month, like where you're going to be able to get it rented to. And one of the biggest problems that owners forget is that you can't seek your damages because you don't know what they are until you have it re-rented.
Right.
So that's why you have to take active steps immediately to go and re-rent that apartment. Now, wait, just get me back onto your last question, because I was in the middle, I had a thought that I was...
Well, the question was about turnover, but let's address that shortly.
Okay.
Unfortunately, we got to take a short break, and we'll be right back. When we first started Excel Real Property Management 11 years ago, we did so with the intention of protecting the investment community. Here at XL Real Property Management, we focus specifically on serving the needs of individual apartments, townhouse, and small multifamily building owners both in Manhattan and select neighborhoods of Brooklyn. Our services encompass everything: rent collection, expense payment, handling maintenance and repair, turnover between tenants, insurance needs. Literally anything that an investor would typically handle him or herself, we take care of for them. Whether you hold one individual apartment or a rental building that houses 20 units, Excel is here to help with all of your specific needs.
What do you really need to know about buying or selling a home? First, it's serious business. And it's complicated. There's a lot of money on the table, and emotion too. You need an agent who knows the ropes. So, whether you're buying or selling your home, work with professionals who have a mastery of the craft.
Okay, all right. So we're here with Jamie Heiberger Harrison, and we're talking about duty to mitigate. Right now, we're talking about what charges we can charge back to the outgoing tenant. And we were in the middle of a discussion about turnover, what damages I can claim from the outgoing tenant. And my question is about turnover. So I just paid $5,000 to paint the apartment. The tenant moved out, 6 months into the lease. I now need to get the apartment back into rentable condition. Can I charge the outgoing tenant for basic turnover? Nothing,
Absolutely.
Nothing, negligent that I would normally deduct from a security deposit, but wall scuffing, holes in the wall from pictures, extra filth from when they were living there. I can charge all that back to the outgoing tenant.
Absolutely.
Okay, that's good news for our landlord. And then I have another question. We have to take lower rent. The law says that we've got to advertise the apartment for either the same or lower. Correct? That's what's stated in the revenue lease.
Correct.
What happens if I get a lower rent? So the outgoing tenant was paying $5,000. The market shifted downward, let's say, and now the apartment's worth only $4,000.
Okay.
Can I charge back the delta between what I was getting and what I'm getting today for at least the remainder of the current lease?
Correct. That's exactly what the formula is.
Okay, so if I was getting $5,000, now I'm getting $4,000. You had 4 months left on the lease. I can charge you back that $4,000.
Correct. Each month.
Each month.
The whatever it is, the $1,000 difference each month. Correct.
Okay, perfect. So I'm glad we can reclaim that cost. And then the other big vague thing in the law is you've got to advertise the apartment for either the same or market rent. And as you know, sometimes an apartment flies off the shelf. We rent it in 2 hours. Sometimes it can take weeks or even months to re-rent the apartment. Who determines what market is?
Well, it's not that it's market. It's either has to be the same or a lower rent. And so if the market, though, were to be higher, like I was saying before, well, guess what? You're taking that chance because you're going higher, so you're not going to qualify to charge it to them. But hey, if that's what it's worth, hopefully you'll get that rent anyway, so that it won't really matter.
Right.
In terms of reasonableness and making that good faith effort, it's a case by case. I would say this: you list an apartment for the same. If after 2 weeks you don't have anybody making an offer, kind of needs to bring it down. You're going to bring it down $1? No, you're going to bring it down a little something so that you bring it to that next reasonable level of what it would be in the industry. Bring it down to there. Run it for 2 weeks. Doesn't rent. Do it again. That would probably be pretty, a good faith effort.
Right.
If you're going to keep it at that rent for 3 months, that's really not a good faith effort.
Okay, so there's no specific time crunch.
No,
because,
there's not.
I represent a lot of individual condo owners. That's what Excel does. And, when it comes to market value, some of our owners believe the market value is $5,000 when the market tells them it's worth much lower.
Right.
At what point do we have to start making reductions to get it to market? As long as we're being reasonable, you say, like, I listed at $5,000 for a few weeks. I don't get it. Maybe 3 weeks later, I drop it by $100. I would still be complying?
I think that when I say case by case, because, for example, if what's Excel's policy, right? Excel's policy. So what are they going to do? They say, well, traditionally, after 3 weeks, we lower it.
Right.
Well, if you do it 3 weeks normally, then don't do it 2 weeks now.
Okay, so it's whatever the normal course
Whatever your
you would
normal
follow,
course would be, correct.
That would be.
Because you can't, otherwise it would be looked at as, well, why would you do it differently? Because you think you're going to stick it on them?
Right, absolutely. No, and my position always comes from some of the unreasonableness of our owners that they believe the market is X and they're going to hold firm. Some of these people hold firm for 6 months because they're like, my apartment's worth $15,000 and I'm getting $15,000.
Right.
And sometimes it works out, sometimes it doesn't. Sometimes the market will change in a way that they actually get it. But that would not be considered reasonable if I waited 3 months to start making reductions. Okay, that's a good clarification because we always get confused about that. And then, sometimes this works out, right? If the market, the market's gone up, and unfortunately, due to Fair Act, will continue to go up just for the foreseeable future. So if I was getting 4,000 today and current market's 5,000, what would the guidance be? Put it on the market for 4,000 and hope it gets bid up in a war?
You know, the problem is, again, you know, when it comes to, if you're talking about where you want to be covered for your liability if your tenant breaks the lease, the only way that you could be covered under current law is to charge the same.
Right.
But if the market went up 5,000, you know, I would rather say to a client, well, it was 4,000. I can't guarantee you that you're protected if you're not going to be protected if you list higher.
Right.
The market might be 5,000. I think your best bet would be listed for 4,500 then.
Right.
And get yourself the higher money and get it rented like that, as opposed to worrying about trying to make a claim that. So that would be my recommendation.
Understood. No, I appreciate this guidance because basically you're saying as long as we're listing it for market, even if the market's a little bit higher, we might be okay. But with the caveat that there is no real case law here, we don't know how the judge would enforce it. Because I think the popular thing to do is if the market went up, you listed it for whatever they're paying now and hope it goes in a bidding war very quickly.
Right.
Because you can't blame. Nobody can turn around and blame the landlord. Oh, well, you signed a new lease for 5,000 when I was paying 4. Like the landlord's not at fault. Well, no, we got 6 offers, especially in today's market where the market is skyrocketing.
Right.
We got 6 offers. We just took the best one.
Right.
Okay, so I definitely really appreciate that guidance. And here's another thing that happens to us a lot. We'll talk to an owner. You know, we have a tenant. We love the profile of a tenant. You know, it's one person. They use it as a pied-à-terre. You know, they live on Long Island or something. They come 2 days a week. They're very light users. You know, they're responsible people. And we recently had a case where somebody wanted to break their lease, and it was in one of our apartments over on the east side. And they moved out, and they said, "Oh, there's somebody in my building who would qualify for the apartment. You should rent it to him." We didn't like the profile. It was now a share situation. They had a cat. The owner didn't want cats. Am I forced to take a different profile than I want in order of fulfilling duty to mitigate? Because the landlord wanted a particular situation, and now while this other tenant was potentially financially qualified, it didn't meet what the landlord really wanted. Not in a discrimination way, but just in we wanted a light user with no pets, and we didn't want a share situation. Like, and he's like, look, if you don't take it, then I'm off the hook. But at the end of the day, I wouldn't have taken that tenant profile for this apartment the first go around either.
Well, then that's your answer. If you wouldn't have taken that profile to begin with. And again, I think it's really going to hinge on what you've done in the past.
Right, absolutely. But that would be the worst court case in the world and tons of discovery because someone's going to come in and analyze my last 100 deals and how we reacted to each intricacy?
Right, exactly.
All right, this is very interesting. We're going to take another short break and we'll be right back.
I'm Brian Scott Cohen, one of the top loan originators in the country and the #1 mortgage originator at Guaranteed Rate Infinity. Guaranteed Rate Infinity arguably has the most advanced tech in the industry. Our completely digital loan process makes it easy and efficient for homeowners, from a 15-minute pre-approval to the digital application and through closing. My team and I would love to help you get into the home of your dreams.
This beautiful set here at Studio 1873 is brought to you by the Everset. The Everset provides full-service staging and furniture rental solutions in the New York area. We work with Brown Harris Stevens and many other top real estate firms, staging their homes to sell quickly and at the highest price possible. Our staging is affordable without sacrificing quality or design. For more information, please visit us at staging.theeverset.com or email us at staging@theeverset.com to request a free proposal.
Okay, so we're back now. And so I don't have to take that profile if I don't want it. And if the tenant challenged me, they're not going to go through my past 100 deals and be like, oh, well, I see in this case you took the cat because we don't necessarily like shares in higher end apartments because, we want a lighter usage. Sometimes shares can be
Well, when
more
you say
difficult to
shares,
manage.
you mean a tenant and a roommate?
Like roommate shares, for example.
Well, the problem with that is that I don't think you can say something like that. That would, because everybody's entitled to one unrelated person to live with them.
Ah, okay.
Every tenant on a lease, including a including a proprietary lease, every single tenant in New York, it's called the roommate law, that everybody's allowed to have one unrelated person live with them. If you have 2 people on a lease, then each one can have one unrelated person live with them. So
Wow, I did not know that.
Yeah, so I don't think that you could really, I think that the share part of it could be a problem.
So let's say it's 3 roommates. Well, no, then again, you
could each have one.
you know, math doesn't work there either.
And, you know, I even think in this day and age, you'd have a problem with the cat, unless you advertised it with no pets.
Right. Except they can complain. They can say, "Oh, well, it's my emotional support cat." Because
well, then forget it. Then
I
you're
have to
stuck
take the
anyway.
cat. Yeah.
Well, that's the thing. I tell all of my clients, put your rules about pets out the window.
Right.
What you should be doing instead, and I would say the same thing to a building or any board, is make the restriction about, you know, the size, let's say, the weight. You know, those are things that you can do. But in this day and age, anybody can have a pet, and
Right.
it's, you know, New York City, where it's a pet-friendly city, and if you're going to own in New York City, then you need to be pet-friendly, I think.
No, absolutely. And then the minute the tenant brings up, "Oh, it's emotional support," or
That's
then
it.
case
And
closed.
exactly.
You know, we're not going to challenge that.
Correct.
One. Okay, so we understand that. Let's see. As far as the FAIR Act is concerned, we're obviously just talking about this. Today's June 12th. FAIR Act just went into the 11th today.
June 11th.
Oh, sorry, it's the 11th today. Sorry, happy 11th, everybody. Today's June 11th. The FAIR Act just went into play, where now landlord or whoever hires the broker is responsible for paying the fee. How does this come into play with duty to mitigate now? Because, you know, let's say I didn't pay a fee the tenant paid the fee 3 months ago to rent the apartment, and now the FAIR Act is in place. Do I now have to, as a landlord, in my effort to duty to mitigate, now have to pay?
Well, what I would
broker
argue,
fee?
I think actually the owners are in a better position as we sit here today.
Right.
Because if you're an owner today you can say, I had to pay a broker.
Right.
Whereas yesterday, you couldn't say that.
Oh, so I could go after the outgoing tenant for
That's
that
right.
fee, potentially.
That's right, potentially,
Okay.
because it's in effect. And how else are you going to rent the apartment?
Right.
You could, now, if you're an owner that lists apartments yourself all the time anyway, then
You couldn't do it
then
because
you
you're
would
not
have a
mitigating.
bad
Yeah.
correct. But if you're an owner that always gave your stuff to your broker that you like to work with, then you absolutely should be able to go after the past tenant for that fee.
So I guess that's actually a silver lining of the FAIR Act, because
For now, for
right
today.
now, because the problem before was, okay, maybe the market's a little weaker and now I have to pay a broker when I otherwise wouldn't have had to. It's a lower market. Landlords were paying the fee. Can I then charge how do I make the case that, oh, well, now the market's worse, so I have to pay a broker fee and charge it back to you? It was probably a weaker argument, but in a way, the FAIR Act actually strengthened it.
For this
For right now.
For right
today,
now.
until we get more guidance or.
Well, no, not just. I don't mean just for today. What's different now is that it literally changed today.
Right.
But if you have a tenant, if you sign a lease now tomorrow for a tenant, and that tenant breaks their lease, the FAIR Act was now and the FAIR Act is then.
Right.
So it's for the people that break it during this window.
Just this particular cycle.
Between now and like a year from now.
Right.
Anybody that breaks their lease between now and then,
Right.
I think the owner has the argument that absolutely they should be entitled to the broker's fee because.
Okay, but after
Because they
this
didn't have-
cycle,
After this cycle,
we
though, I
might
don't
not
think you
have
could
a strong
argue that.
argument.
How could you argue that? Although,
well, I guess it's a cost. I have to re-rent the apartment, and I have to pay this cost. So
Correct.
shouldn't you have to pay it as
Well,
a tenant?
well, the argument can be, the answer is that it depends, because what's going to happen is owners are going to change their behavior
Right.
now, right? So now owners that are renting their places now, are they going to list them by themselves right now for now? Are they going to try and do that?
Right.
And
I think that'll last for 1 week, and then the
I-
owner does not want to be the broker. They're like,
listen, I
give me the broker. I'll pay the 8.3%.
Exactly. Exactly. It's no different than if we were to speak to 10 random brokers that do business normally today, and we said, how many of your deals have you had a problem with the buyer's broker getting paid from the seller?
Right.
I'm going to tell you that more times than not, if there are 10 brokers that are real brokers doing business, the answer is going to be none.
Right.
Because why? Because same thing I'm going to say to all of my owners and my sellers. They ask me, I get sent, brokers don't even realize, but at least for me, I get sent the exclusive agreements on a regular basis from my clients.
Right. They want you to look at it and make sure that
I
they're
want to
protected.
hire you. I also want you to review the agreement that the brokerage had given me.
Right.
And so I say to them all the time, I want you to give whatever you're giving the seller. Other than the seller, maybe a quarter or a half more because they're going to pay for the marketing.
Right.
But other than that, if the buyer's agents are choosing where the buyers are going. That's the reality.
Right.
So don't you want them to choose your place to go to?
Yeah.
So that's it. You want to get the place sold. What are you haggling for? You were willing to pay 6% on a or 5% on a direct 3 months ago.
Right.
So why are you trying to haggle now with the buyer's broker now that it's changed?
Right.
Shouldn't
Absolutely.
be any different.
No, I fully agree with you there.
So that I really feel like we seamlessly got through it.
Right.
This, this is going to change the industry, obviously for the worst.
Right.
For the worse, I should say.
It'll be just like the 2019 rent laws where it was a lot of populist agenda, but it backfired. And already I looked at Street Easy today and median rent in New York City went up by 2% in one day. Today, now that it started, because now landlord doesn't have that 8.3%. They've got to bake it into the rent, and you just made the market much more expensive than everybody.
Right.
Now, I have a last question on this whole topic. And, one thing that concerns me is typically before the tenant, abandons the apartment and moves out and hands you back the keys, is they reach out to you and they say, hey, I need to break my lease. Sometimes it's, a reason that's not, life-threatening or detrimental, like, my partner died and I can't afford the rent, or,
right.
Or hey, I just hate my roommate and want to move out. Like, what would you advise a landlord in the case the tenant calls me and says, hey, I can't pay the rent anymore? What should I wait for them to give me back the keys, or is it better to get ahead of this? Because if I'm a landlord and you're a tenant, you're telling me you can't necessarily afford to pay the rent, I don't know if I'm doing myself any favors by holding you to the lease.
Absolutely not. I mean, if somebody is giving you a courtesy of telling you that they really don't know if they could afford the apartment anymore,
right,
then work with them to create a situation that you suffer the least damage.
Right, absolutely. Because I don't want to chase you. If I have to go chase you for rent, I've got to get a lawyer, I've got to go to court. You may not have the money, even if I win a judgment. So I'd rather play ball and not, be like, oh, when you give me back the keys and move out, I'll try to limit your damages. I want to get ahead of it to protect myself, and also from a humanitarian spirit. If you've got, an illness or something that you're going to be down, I don't want to cause one more strife in your life.
Right. The only other thing I would say to that is that sometimes in that situation is, can they not afford it at all, or could they just not afford this amount? Because then the question is that does it make sense for the landlord to lower a rent even if they can get the higher rent from another tenant?
Right.
Sometimes it does make sense to do that.
Right, absolutely. And, we want to play ball. We want to protect our interests. We want to try to protect our tenants to the extent it doesn't cause us a lot of pain. So I could definitely see that being a real thing. Well, this has definitely been great. I, as a landlord who do tons of this, had so many questions, and you've answered so many. And thank you so much for all the wisdom you've imparted on us today.
Thank you so much for having me here. It was great.
Great. Thank you so much, everyone. We'll see you next time.